Yeah. Okay. I hope you can hear me now. It seemed that it is.
Yes.
Should I just start? Okay. Thank you. Thank you everyone for joining this session, and thank you for the organizer for allowing us to join this conference. In this panel, we are going to provide you a showcase of what we are doing here at Vollenhoven Institute in Leiden University. You will learn and be familiar with our work. We will first present some of the PhD projects that we're doing, and also some of the research projects and also implementation projects that we're doing at VVI. There will be a really short Q&A in the end, but you are also always welcome to post your comments or questions in the chat. So, without delay, I would like to introduce you to our director, who will give us the first overview of Van Vollenhoven Institute, Professor Adrian Bettner.
Thank you, Santi, and I'm happy to be speaking at the winner. I hope you can see the slides, or how do we share the slides? No. They will operate the slides. Yeah. Okay. Yeah. So I just shout next, and then the next one. So the first one is a research at Van Vollenhoven. Yeah. Back. The first slide. Yes, that's the first one. Okay, this is we'll try to, as Santi said, give you a showcase of what Van Vollenhoven does, the kind of research we're doing, the projects we're involved in, and I'll start to give you a brief introduction, starting with the next slide, in which on which you can see all the PhDs that have been written at VVI on Indonesia since 1996. And a lot more to follow soon, as you will know after this session. Themes that we've been traditionally looking at are legal institutions. That started with Dan Leff's coming to the VVI and several of the PhDs and a lot of the research about courts in particular, but also the Gadjah about lawyers, about legal education. The other major theme has been family law, a lot about Muslim marriage and divorce in Indonesia, and natural resources, which forms a really important third cluster. Having said that, I should also add that we're broadening, and you can see that several themes which are not easily brought under these headings actually are being researched at VVI, such as data protection and a lot of criminal law, actually. Next slide. Yes, it's this one. So the theories we are using are what we're referring at concern legal pluralism, so Adat law, religious law, and its relation to state law, access to justice, to what extent do ordinary people in Indonesia have the possibility to actually have their rights realized, what are the obstacles they're facing, questions connecting to such issues, dispute resolution, how do disputes evolve, what kind of procedures do people follow. And then an important one, and you will see that later on, I'll talk about that when I discuss later, the LAMPU project is lawmaking. So how are laws being made? How do they actually come into place? What kind of political and what kind of legal factors and actors influence that process? And very importantly, perhaps rightly at the center, is rule of law. So to what extent is there a rule of law in Indonesia, and how do we have to understand rule of law, and what are the factors that promote or discourage the establishment of rule of law? Then moving to the right, we also look at implementation of law. So to what extent, what are the problems that are marring the implementation of law, and what are factors promoting it? What do we see? What do we see happening? And then there's legal consciousness, which is an important factor connected with access to justice. So how do people perceive the law? How do they think about law, and how does that influence the way they actually they act in practice and they make use of it? Now, methods we use in research are mainly qualitative, but within qualitative research, we also use surveys and other more quantitative analysis. Ethnographies are really important. All our PhD, or almost all our PhDs, do field research. Combining this with, of course, not only legal analysis, actually, but more broadly, the analysis of documents, but that can also be part of the ethnographies. But so we're very much part of an anthropological as well as, or sociological as well as a legal tradition, and we combine the two. So we try to be truly interdisciplinary in our approach. Now, I asked all the PhD students to send me a picture representing their research, but I only received 3 on time to put them here. I will not go into them, but you can later guess from which projects these pictures were taken. But all the PhD students are here, and they will discuss their projects by themselves. So without further ado, I now hand over to Faiz, who is going to talk about data authority and interest.
Okay. Yeah, thank you very much, Pak Adrian. And good morning from Leiden. Good afternoon to our colleagues from Indonesia. My name is Faiz Rahman. I'm a PhD researcher at VVI, and my research explored the intersection of law, politics, and technological development by examining the lawmaking of personal data protection regulations and its historical aspect, so the genealogy of personal data in Indonesia. And for my research, I especially examine the PDP law and its implementing regulations. And this is important because personal data now has become a key resource in utilization and development of nearly all digital technologies, including those utilized by state actors. And the use and misuse of personal data also have a significant implications, not only for citizens, but also for society in general, and also even for state institutions. And this also means that the utilizations of personal data through various digital technologies may drastically reshape the state, citizens, and even society relationship in the digital era. And in this research, I particularly put emphasis on the conceptualization of public interest provisions based on at least 3 interrelated reasons. The first one, public interest is often positioned in conflict with individual interests, and this tension is particularly explicit in the general elucidations of PDP law. And the second, public interest is deemed an inherently contested concept with its broad scope and lack of universally accepted definition. And the third, public interest is perceived as a symbol of state authority and a legitimate basis for states' utilizations of citizens' personal data. And therefore, how public interest is conceptualized within the PDP law regime will determine the extent to which state power over data is meaningfully limited and how effectively individuals' constitutional rights are protected. And the lawmaking analysis of the public interest provisions in the PDP law regime is helpful to understand how state-citizen society relationship being reimagined and reshaped by the conceptualizations and implementations of public interest provision within the framework of democratic rule of law, and what factors influence the conceptualization, and why did they keep the broad and vague interpretations of the provisions, and what are the impacts and potential risks arising from such unfinished conceptualization. And you can see on the slide the temporary finding of this research reveals that the ego-sectoralism and previous imaginaries of personal data substantially influence how public interest provisions were conceptualized. And the broad and vague provisions can be perceived as a compromise to preserve sectoral authorities over data, as it could accommodate diverse interpretations. The second one, public interest provisions, can amplify the exposure of potential harms for citizens, society, and even states institutions under two interrelated conditions. The first one is unclear normative safeguards, which include, for instance, potential mitigation, sanctioning provisions, and the independence of design of the data protection authority. So it's related to the meaningful independence of the data protection authority. And the second condition is about the institutional dilemmas, which related to ecosectoralism, technological adoption, and also digital readiness. And the third finding, temporary finding, state-citizen relationship in the digital era, especially in the data protection regime, cannot be seen as a simple relationship between two actors, but rather as a complex relationship between citizens and multiple state actors that is shaped and intensified by various factors, including institutional landscape, for instance, the ecosectoralism issue, rapid technological development, and how the government institution officials they can mitigate the potential risks, for instance, and the societal dynamics, including the, for instance, digital literacy, and then digital gap, and so on. And the fourth finding is that diverging interpretations and implementations of public interest provisions can inadvertently allow digital authoritarian practice by potentially authoritarian actors. So I think that so far my research, and it's still ongoing, and now I'm still working on the implementation phase in the soon to be GR government regulation of PDP and interpretation by the judiciary, for instance. Okay, now I'll give the floor to Dila.
Okay, thank you, Faiz. Thank you the committee. My name is Fadilatul Hikmah. My research is about the Indonesian tax court, and the title is Judicial Independence and Impartiality in the Global Tax Environment: The Indonesian Tax Court Experience. First, to give you a sense why this topic matters, let me start with some background about the tax court and the scale of tax disputes in Indonesia. Tax disputes in Indonesia have grown significantly. As an example, in 2024, the tax court received 14,642 new cases and carried over 10,455 from 2023, bringing the total caseload to 25,097 cases. Each judge had to handle 700 decisions in a year, which is a heavy workload. And many of these cases involve international tax issues such as tax treaty interpretation, transfer pricing, investment treaties, and trade agreements. Historically, and even today, the tax court has operated under a two-roof system, which means that it is supervised by both Supreme Court and the Ministry of Finance, which has long raised concerns about its independence and impartiality. In 2023, the Constitutional Court annulled Article 5, Paragraph 2 of the Tax Court Law, mandating that the tax court be placed fully under the Supreme Court by the end of 2026. To illustrate, still the previous slide. So to illustrate why this institutional change matters, let me draw your attention to two key points highlighted in this slide. First, all the information that I provided here is to show that there is a tension between revenue-oriented tax administration and the need for impartial judicial review, as Indonesia relies heavily on tax as its main source of state revenue. The tax court is vital for fair dispute resolution, maintaining investor confidence, and enforcing the rule of law. And secondly, in the central image, you can see a tax court proceeding that I captured during my fieldwork. At first glance, it may seem unremarkable, but the details reveal much about the current institutional condition of the tax court as institution under pressure and the ongoing concern over its independence and impartiality. You can see that the representative of the Directorate General of Taxes on the right-hand side and the court clerk left-hand side, they're both wearing the same white uniform. The appellant is not visible there because they joined the session online, but notably they did not wear any kind of uniform. The judges are in their official robes, yet during my fieldwork, I observed that some judges also wore the same white uniform. I later learned that this uniform is provided by the Ministry of Finance. This detail about the uniform is not merely superficial, it carries historical and political meaning. It calls to mind the earlier trend during the former Indonesian president era, symbolized by the slogan "Kerja, kerja, kerja," work, 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 as reflected in the uniform. This imagery underscores the strong influence of the executive branch over the tax court. Next. Despite the tax court pivotal role, there are lack of systematic studies on how the court actually resolve dispute with international aspects. Previous literature often focus on administrative law, administrative aspect, tax policy, international tax, but rarely look at the tax court as domestic actor in the global tax order. So my study aims to fill this gap by exploring the tax court's independence, impartiality, and performance in resolving such disputes. Next. So my research is guided by four main questions. First, how does the tax court decide cases involving international tax aspects? Second, what institutional, legal, practical, historical factors that shape the court's performance? What do the cases reveal about the court's independence and impartiality in a globalized tax environment? And lastly, what reforms are needed to strengthen its role as an effective judicial actor both domestically and internationally? Next. Next. I will skip this one. Okay. So I use socio-legal and qualitative approach, combining doctrinal analysis of case law with fieldwork-based empirical research. To address my research question, I rely mostly on decision of the tax court and the Supreme Court from 2002 to 2024, with a focused review of cases brought to the Supreme Court and also other relevant decisions. Statistical data from Director General of Taxes and the Tax Court Secretariat, and also interviews with key actors, judges from Tax Court, Supreme Court, Tax Court Clerk, Supreme Court Clerk, officials from the Tax Authority, as well as tax lawyers and consultants. This mixed approach will allow a comprehensive mapping of tax dispute with international aspect and evaluation of the court's performance, its decision-making quality, consistency, independence, and impartiality, and a better understanding toward domestic court's role in international dispute resolution. To conclude, understanding the Indonesian tax court independence and impartiality is crucial not only for domestic tax justice, but also for international investor confidence. In today's connected world, where global tax disputes increasingly intersect with national court, strengthening the credibility of the tax court is essential for a fairer and more reliable global tax environment. Thank you very much, and I look forward to your comments and questions.
Yeah, good afternoon, and my name is Todi Utama, and my research explores how adat is incorporated into the state's legal and political systems. So in my research, adat refers to indigenous or customary laws, institutions, and also practices. So we often associate adat communities with being isolated, far removed from the state governance and the market economy. However, that is not always the case. My fieldwork in Bali found that adat institutions play important roles in the island's local governance, politics, and also as well as the tourism industry. So as you can see in the picture A, many banjar or hamlets or sub-villages in Bali manage waste collection and recycling, waste management. Some of them also provide early education services. Picture C shows how the hamlet in Denpasar used the second floor of its community hall as a preschools and kindergartens. Meanwhile, picture B shows the launch of an adat village regulation on shared internet poles in Intaran, Sanur, Denpasar. So they try to prevent their territory full of tangled internet cables and poles, as you may be also familiar with your area. So these tasks usually fall under the responsibility of government's office. However, in this case, and in many cases in Bali, regulating internet infrastructures or providing public services carried out by adat institutions. Beyond this example, adat institutions have long partnered with regional government in various public services, such as COVID-19 vaccination or even rabies eradication. They also manage local banks and cooperatives, tourism sites, parking facilities, and other community services. Next slide, please. At the same time, adat also serve as a political force, suppressing dissent or counter-oppositions. Picture A shows that in response to protests and riots across Indonesia in late August, the Bali provincial government and also the Bali Adat Council gathered tens of thousands of pecalang, the Adat security forces, from around 1,500 Adat villages in Bali. So the rally declared that the pecalang readiness to protect Bali from violent protests. Picture B shows similar declaration, but it happens in North Sulawesi, where the Pasukan Adat Manguni Makasiau, a local Adat vigilante group, warned the protester through TikTok videos not to burn or damage government and parliament building. And on the picture C, we can see a different occasion. In April 2025, Saifullah, the one who sit with a blue shirt, post a parody video mocking the governor of Central Kalimantan, who is also the leader of indigenous group known as Dewan Adat Dayak. Not long after that, he was summoned to an Adat court held by the Dewan Adat Dayak. So the court viewed the parody not only as an insult to the governor, but also an offense to the dignity of Dayak's people, the province dominant ethnic group. So Saifullah was fined 20 million rupiah, or about 1,000 euros. So why does this happen? From the example mentioned earlier, we can see that Adat serve multiple and shifting purposes for the governments. On the one hand, Adat institutions have increasingly become partners for regional government in delivering governance and public services, and also development goals. And on the other hand, Adat mobilization can also serve as a power reserve for regional government. It can be activated to provide legitimacy, enforce government policy, bargain for resources, or manage political oppositions. And how is this achieved? For the case of Bali, the provincial governments use combination of policy making and budgetary support. So in addition to dozens of regulation to Adat, the provincial government also distribute annual funds of 300 million rupiah per year for every Adat village. And this also, together with that, the government also employs some narratives or cultural framings to give the sense of external force that treating Bali and then the state's position as the gatekeeper of Adat. So yeah, what can we learn from this? Actually, that on the one hand, it's always good to have Adat support the government, but on the other hand, it's also there is an expanding Adat authority that brings certain risks. And as Mahmud Mamdani warns, the centralized power can turn into the centralized despotisms. Thank you very much for listening, and I look forward for your comments. Thank you.
Hello, everyone. I'm Gadjah Tuslian. I'm a PhD researcher jointly appointed by the Vollenhoven Institute and the KITLV, the Royal Dutch Institute of the Southeast Asian and Caribbean Studies. So my research is about the infamous water struggle in Jakarta, the natural resource allocation, the one of the most essential natural resource, which is water. But I see it through the lens of citizenship, but not citizenship as a nationality, fixed legal status denoting membership in a sovereign state, but what I called a substantial citizenship, a flexible and contingent form of political subjectification that emerged through the continuous performance between the state and its citizens. In Indonesia context, in line with the scholars who have examined its fragmented characters, citizenship is not simply possessed, but continuously mediated through networks of connection, bureaucracy, and in my case, negotiation. It is through this lens that my encounter with water struggles in Jakarta's urban poor coastal kampung opened up new ways of understanding of how citizenship is produced, recognized, and denied. At first glance, water might seem a purely technical issue about the pipes, well, or infrastructure, but in Jakarta, questions of who gets water, how, and on what terms reveal deeper struggle over recognition, belonging, and right to the city. Next. So although there was some legal changes, mobilization, and Indonesian constitution itself guarantees every citizen the right to water, in practice, access exposes hierarchies of recognition. The city's network supply maps uneven geography of citizenship. Some neighborhoods are rendered visible through pipes, meters, and state investment, while the others remain literally off the maps, beyond the reach of the infrastructure that signify belonging. So my research examined how residents experience and navigate this exclusion, and crucially, how they actively remake citizenship from below. Communities organize collectively, negotiate with officials, collaborate with civil society groups, and sometimes resist projects that threaten their homes. These everyday practices are not only about gaining water access, but about claiming recognition, dignity, and political presence. In doing my research, I incorporate socio-legal approach, combining legal and policy analysis with intensive ethnographic framework. I did FGDs, interview, engage with various stakeholders, including government, official, NGOs, and grassroots communities. But most importantly, I did intensive participant observation, living and engage in the community for almost a year and doing action research that triangulating my data. At the end, I hope that my research contributes to broader debates on citizenship, inequality, and governance. And through the lens of water, my project reflects on a broader question: how do Jakarta's urban poor make themselves visible as citizens?
Good afternoon. My name is Vera Winistijawati Sumarwi. This moment, I will present my PhD research project. I have observed the effort of the urban riverbank dwellers in Ciliwung River since 2012-2022. The results of my observations are presented in my PhD thesis. The title of this presentation is a grassroots legal mobilization in normalizing the river in Jakarta. Next slide, please. Yes. The key message of this research are stop expropriation, stigmatizations, and applying enforcement law. Stop applying enforcement law and unlawful discretionary power, and no buzzers, no influencers, and no violence. And the abbreviation is BIF. Next slide, please. Yes, the research background, a climate adaptation project in Indonesia. Indonesia is one of the countries most severely affected by natural disaster, largely due to the climate change. In highlighting the natural phenomena, I choose Jakarta as a project location because it has been affected by flood disaster and land subsidies. The government's program in Indonesia involved river normalizations at the Ciliwung River in Bukit Duri, South Jakarta, and Kampung Pulau in East Jakarta. The research focuses on scrutinizing the land's historical ownership by the dwellers, the riverbank dwellers, and then the spatial history in the research locations, informal governmental measures applied during the implementations of the project, and the grassroots legal mobilizations. The fundamental research questions are why marginalized people like urban kampung dwellers' property, land, water, river unprotected as easily expropriated by local governments. And then the second research questions, why are their citizens unrecognized, easily to stigmatize as squatter or illegal residents by municipal governments? The third, how did the applications of informal governmental measures impact society? And then the fourth, what are the obstacles and barriers for the marginalized people in accessing justice at the court? The goal of the research project to map the obstacle of grassroots legal mobilization in seeking justice through legal and political opportunity structures, to portray the cause of impediments of local governments in carrying out their legal obligations as governed in the land acquisition law and government administration law. And then the fourth goals is codifying and proposing elaborating the rule of law principle for urban development. Next slide, please. This is the locations of the normalization project. One of the research findings, informal government measures are utilized when the government executes a program or project by applying unlawful government means that are not mandated by law and regulations. The meaning of informal government measures is instrument installed informally by state apparatus that recruit non-state actors informally to execute the state apparatus plan and follow their instructions. These plans are not considered state program as defined by law and or regulations. This thesis found that the applications of informal government measures after the 2014 Jakarta Spatial Planning was forced. However, the Ciliwung River normalizations was not adopted under these regulations. These informal government measures began with concepting media campaign, stigmatizations, public legitimacy, defeat and conquer tactic, unlawful discretionary power, applications of enforcement law, and forced expropriations. The meaning of unlawful discretionary power in this thesis is that the provincial government does not have the power to change the delegation mandate under the land acquisitions. The law clearly mandates that the government should conduct land acquisitions for public interest development projects like water management and river management and slum upgrading. Furthermore, discretion was decided without public participations of the representations of group or interest group. Moreover, it is not in accordance with the framework of legal principle governing the exercise of discretionary power as stipulated under the administrative government law. The conclusions. The vernacular kampung such as Bukit Duri and Kampung Pulo has been recognized as having legitimate land ownership status, including kampung residents and citizenry of the kampung dwellers since colonial governments. For example, in Kampung Pulo, in 1995, the local authority at the village level, Lurah Kampung Melayu, exercised its power by issuing a letter and land transaction form, sale and purchase above the state land. Although the head of the village or lurah local governments had no legal mandate to change the dweller's land status for customary land title for Ponding Indonesia Partikular and Giri to state land, in reality, they exercise their power to change dweller land status. The land political economic policy of the city governments, my friend has remind me that the time is end up. So for further information and questions, you may send me email or you can read my thesis and then you can contact PVI. Thank you very much for your attention.
Yeah, good afternoon, everyone. My name is Anugrah Akbari, and I'm here to present my research, which discusses the formulations of national identity in the making of post-colonial Indonesian criminal code. So if you remember, last August, Indonesia just celebrated its 80th independence. So it means 80 years ago, the colonial government stepped out of the country, and Indonesia decided to become a sovereign nation. But the problems for a country which has a very diverse characteristic as Indonesia, and also size-wise, it's all bigger compared to all the nations in Europe combined all together. So it's very different. It's very difficult to unite the nations. So indeed, Indonesia has this independence, but the Indonesia's identity is always contested. In some research, it has been confirmed that the identity of Indonesia is merely a reaction of Dutch colonizations. And the problems appears, next slide please, when in 1961, the state sort of like initiated the Indonesian New Criminal Code project, which was originally designed to sort of like decolonize the criminal law, but also to build the nations in terms of formulating its own national legal system. But the problems is this project has been so long in the Indonesian legislative spheres. It started in 1961. It's only concluded 3 years ago. A lot of things have changes. The political regimes changes several times, and also the society evolved. So my research, next slide, is intended to address these issues. Basically, it will explain how the hell did it happen over times. So in the next slide, you could see, although there are so many things to be discussed in the code. So these are the six main debates, and also state claims of the Indonesian values. So we still want to defend capital punishments, and also we also criminalize crimes against state ideology, which has history back from 1965. And we also decided to re-invoking the unconstitutional provisions of insulting the dignity of president and vice presidents, as well as other beliefs. And these were, I believe, these were proposal that was floored by the conservative integralist proponents, as well as Islamism, with specific focus on criminalizations of fornication and cohabitations. From here, you could say that at the glimpse, Indonesia sort of like took a step backwards in our democracy. But you could see at the end of the product, when next slide, in the final outcome of the code, there were so many altercations to this sort of like conservative provisions. So there were a narrative of human rights which makes these provisions not entirely so bad. So for instance, indeed, we're criminalizing the insulting the dignity of president and vice president, for instance. But then the code make it really hard to implement because it was designed as a complaint-based offense. It's also the case with crimes against that ideology. You cannot spreading sort of like Marxism, communism, but if you do it under the narrative of scientific activities, it was all good. Also, we previously has blasphemy laws under the current criminal code, but even if we have now the crimes against religion and beliefs, we now deleting the blasphemy, and we change the narrative into hatred towards religions and belief. These are major changes to the code, and also the progressing democracy that we have at the moment. And what do we say about this? So basically, a criminal code project is a battlefield of ideologies and interests. And 4 decades ago, next slide, Ben Anderson argues that there were three institutions of power that shaped the way the colonial state imagined its dominion. It was census, it was math and museum. And through this research, I would argue that law, especially criminal law, has also the function of imagining of the political society of Indonesia. That is my questions. That is my presentation. If you have questions, could you address at the end of the sessions? And I'm now handing the sessions to Nanda.
Okay, everyone. My name is Nanda Amalia. I would like to start my presentation by sharing to you the moment, the experience when I came first time. I arrived in Singkil, one of the remotest island in Aceh. I was struck by how far everything seemed, not just as the distance between island, but also between people and the institution that claim to serve them. A woman, one of my informant, once told me while she was sitting quietly on her wooden porch, we wait for the sea to come before we cross the court. That journey, physical, emotional, and legal, is where my research began. My dissertation asks in what ways do people, particularly women in Aceh, navigate marital breakdown and pursue justice across plural legal system, and how do justice provider engage with this effort? This question didn't come from books or legal theory. It came from conversation with women like Rania, who remained in uncertain marriage long after love and trust had disappeared, with men like Samsul, who saw divorce as a right, not a dialogue, and with Gadjah, the local village elderly and judges who tried within their limits to make peace between law and life. I work in two different parts of Aceh. In PD, the Sharia court in Sigli was a visible institution. Its building stood firm, its judges busy, its corridor always full. But in Singkil, justice traveled by boat. The formal court was hours away, and people often relied on adat or endured in silence. In those remote villages, I saw justice as something improvised. A conversation sometimes happen in the kitchen, a meeting under the in the musola, or sometimes whisper decision to wait, because sometimes doing nothing is the only form of agency available. One of my chapter looking into the experience, the everyday life of marital breakdown. It begins with this personal story. It maps how marital conflict unfold before it ever become a case. Through Rania's story, I trace how women name their grievance and test their capacity to act within tight social boundaries. In the following chapter, I move into the adat arena where community justice meets moral negotiation. In PD, the Gadjah still mediate dispute in front of elderly, invoking Islamic and customary value. Here, justice provider carry heavy burdens. They must protect both the women's dignity and also the village reputation. Through this story, I saw that adat is not a fixed tradition, it is a living forum, shaped by empathy, hierarchy, and survival. In the following chapter, I turn to the courtroom. Women like Bulan and Hanifa come to the Sharia court, to the religious court, seeking formal recognition of what they already know, that their merits are over. The court become both a space of validation and also vulnerability. Procedures are strict, evidence is required, but in the pause between testimony, something deeper emerged, a sense of moral reasoning that blends faith, fairness, and sometimes fatigue. Through these cases, I argue that justice is not just a verdict, it is an emotional process and life experience. And then in the following chapter, I look into the judges themselves. In Sigli and Singkil, I observe how judges interpreted the law through the texture of daily life. They quote Quranic verses, they consult legal codes, but also listen to a woman's silence, a husband hesitation, and also a village expectation. Their discretion is not merely technical, it is a moral and also pragmatic. Drawing from Verhoeven's discretion framework and also Bedner's idea of legal differentiation and Bowen's motion of public reasoning, I show how judicial reasoning in Aceh is a form of moral translation, where the boundaries between law and life constantly blur. Across of this chapter, one theme persists, the limit of redress. Access to justice in Aceh is both real and fragile. It depends on distance, courage, and also recognition. To seek justice is not only to enter an institution, but also to awaken to one's own voice. I remember one of my informants said, after years of uncertainty, when she came to the court, she said in Acehnese, "Nyo lon kabedoh." Aku sekarang sudah sadar. Her word remind us that justice is not only delivered in verdicts or document, but in the quiet moment when a person realizes they have the right to be heard. Thank you.
Okay, there I am again. Talking about LAMPU very briefly, you can see that the slide shows the picture of Jacqueline Fell, who was the one who initiated the project and is still involved, but she's now retired, so we have to do most of the work ourselves now. So how did the project start? We found that so many researchers were actually working on lawmaking, and already in the past we did quite a number of studies on lawmaking in Indonesia. We thought it would be a really good idea to write a book together on this issue. So not a real edited volume in the old-fashioned sense that everybody just has his topic and writes something, but that we really try to make an integrated volume in which we highlight the various aspects of lawmaking in Indonesia. So, for instance, Eki already presented his PhD research on the criminal code, and he is showing how it's kind of a national symbolic project and how important this symbolic significance is as an instance of nation building. Whereas Faiz, who presented his research on the data protection, shows in his chapter, for instance, what the influence of experts has been, and also what it means that MPs are quite have a lack of knowledge on the subject, and how difficult it is then to actually deal with those voids of knowledge. So we try to get to theoretical innovation here as well. So it is a book about Indonesia, but we reflect on general theories of lawmaking as they have been formulated by people like Bucky, Chambliss, and also other researchers, more political scientists, and try to write a book which is not only interesting for those studying Indonesian politics and law, but also for socio-legal scholars interested in lawmaking more generally. And if you want to know more about the project, then you can take a look at the site, the website, where it is further being described. And with that, I hand over to Sartika, who is in Jogja and who will present about the PINTAL project.
Okay, thank you for the opportunity. I would like to share about the PINTAL project which started in 2023. And the background was it started from the awareness that teaching adat law or customary law, often people said, it's not only it shouldn't only use the doctrinal approach, because if it's only use the doctrinal approach, then it will be difficult to understand the complex reality of the community themselves. Therefore, then it is needed to kind of new approach on how to teach adat law, and one of them, like what Adrian have just mentioned in the beginning, the use of legal pluralism as an approach to teach the adat law. And then from this, then we try to make some activities which is started from 2023. Once Jacqueline came to Jogja, and then with Adrian in 2024, we managed meeting on innovations of teaching adat law with adat law lecturers from across universities in Java. And then in 2024, me, Todi, and then Monique also in here, and then some adat law lecturers gathered in again in Jogja, and then we discussed more on how to innovate the teaching of adat law. And then in 2025, we tried to make panel discussions, round table discussions in Socio-Legal conference in Jakarta. And then after that, Todi, Jacqueline, Ricardo, and Adrian, they made about joint publications about new ways of adat law teaching. And then this, I suggest that you can read these publications to understand what is the challenge and what are the opportunities for the adat law teaching. And then our next agenda, we try to develop network of adat law lectures in Indonesia, and then we are for the nearest agenda, tomorrow we will have a meeting with adat law lecturers from Java, from Sumatra, from East Nusa Tenggara and Bali to discuss what can we do next to innovate the adat law teaching. And we try, this is for a long run, we will make a textbook for teaching the adat law. And then we try to support the adat law lecturers and researchers who often isolated or marginalized in their faculties by trying to connect with discussions as well as network with the similar debates of adat law or customary law teaching, not only in the context of Indonesia, but also with the Asia Pacifics and the Pacifics and Africa. So we try to broaden the perspective as well as connected more people to support each other on how then we try to innovate the teaching of adat law. Thank you.
Okay, I will continue the presentation. So my name is Tita, Iftita Sari. I'm a researcher at Institute for Criminal Justice Reform, or ICJR. Thank you so much for this opportunity to present and share our project collaboration between ICJR and VVI, which was conducted on last year, 2024, actually. So for a short introduction, what's ICJR is a NGO, research-based NGO. We are working for advocacy works on the issues of criminal justice reform, so criminal law and criminal procedural and criminal legislation in general for the policymakers as our main targets. And in the last few years, we are focusing on the issues of new criminal code. So we had enacted a new criminal code before the slide, please. Yeah, it's not yet. Okay. So in 2022, we have a new criminal code finally, and then it will be entering into force in the next 3 months in 2026. So between those 3 years, the policymakers, the government will prepare implementing regulations on that, and that's also main works for ICJRs to provide technical assistance for the policymakers. So that's why we are focusing on enhancing the capacity of the policymakers, and therefore the project called Training for Trainers. It's quite relevant with our work as well, and also the needs for the Indonesian policymakers during the last few years. And then in this project, we collaborate with the Directorate of Legislation from the Ministry of Law as the participants of the training. So there were more or less 11 people for the policymakers in the Ministry of Law that is involved in this project. And this project is also supported by the Embassy of the Netherlands in Indonesia. And next slide. So this project actually focusing on the two issues, criminal legislation and alternatives to imprisonment. So we choose those two main issues because we are still having challenges in having a legislation map, especially criminal legislation map, to produce a criminal act in a more systematic, in a more robust way. So that's why we are facing a problem of overcriminalization, inconsistency of the use of criminal sanction, for instance. So we try to figure out how we should have legislation guidelines, for instance, for the criminal legislation issues. And the second issue is about the alternatives to imprisonment. We think it's very important because this is a new arrangement introduced by the new criminal code. So we particularly focus on the community service in particular because we actually have this in the juvenile system, but for the adult system, it's the new type of criminal sanction, and therefore we have to prepare many things, including infrastructure, legal infrastructure, apparatus, and other technical matters. So this training is actually provide a comparative perspective between how the Netherlands have more experience in providing alternative to imprisonment, and also have best practices in conducting criminal legislation as well that we can learn. So this project on-site training, we have 5 days of on-site training in Leiden. We involve Directorate of Legislation in Criminal Chambers from the Ministry of Justice and Security, and also we have a site visit to the reclustering as well. Other than that, we also collaborate with the Department of Criminal Law in Leiden University, Prof. Miranda Bon, Prof. Jeroen, Pina Rocher, etc. Before we are coming to the Netherlands, we also have conducted pre and post training pre-training activities, particularly in Jakarta. We involve the drafting of the new ICC, the new criminal code, Prof. Topo, to have a better understanding about the context of Indonesian. And also we have Dr. Farizal Afandi as well, who was conducted his PhD program in the Netherlands as well. So he has a more better understanding of the Dutch context. So before we go to the Netherlands, we ensure that the participants is clearly understand about the context. And post training, after we are finishing the training on site in the Leiden, we also hold a post training to ensure that what they are gained from the on site training could be implemented in the Indonesian context as well. And we invite speakers from the reclustering to oversee and to give feedbacks about the progress that the policymakers have conducted during those after a few months after the onset training. And also we invite the local relevant stakeholders, for instance, prosecutor and also probation officers, to have feedback about how the policymakers make progress on preparing the implementing regulation, particularly on the alternatives to imprisonment and also criminal legislation. Next. So this project is not only finished or stopped by conducting and training activities. We also try to make a documentation of this project so that the policymakers can refer to any time to this document and see what they have already learned during the process. So in the first stage, they will try to identify what are the problem or the requirements that they need to identify to prepare the implementing regulations. And then the second step, they need to contextualize the problems and the requirements between the Indonesian context and the Dutch context, which has quite very different practicalities. So they try to document that. And then also stakeholders mapping, it's also important because one of our findings during this project is that the policymakers sometimes has less contact with those officers in practice. So that's why the implementing regulation in so far is still lacking and has difficulties in the practical matter. So that's because it's because the local and also the practical officers rarely have a chance to really talk to the policymaker sitting in the central government, for instance. And also lastly, about the relevant and realistic timeline project or program, because it was conducted in the only 6 months, 1 year and 6 months before the new criminal code will be entered into force. So there is clearly a time constraint for that. So that's why they need to make a prioritization and also realistic timeline to ensure that this implementing regulation will be ready before the entry into force of the new criminal code. And also during this process and also in the document as well, we received some feedback and also comments from our trainers as well. For instance, Prof. Adrian and Prof. Jeroen. So after all of the participants make a presentation about their findings and their analysis, they are receiving feedback from the trainers saying that, for instance, we need to really document the the process of legislation in a details, because it's very useful when it comes to the practical in the implementation of the regulation itself. And then for the implementing regulation, we also learn that there needs to be some room for discretion, for instance, for the law enforcement during the practice, because it will give more easiness for the practicality. So it's not really more detailed, and yeah, there is a balancing issues between in detailing the regulation and also give more a room for discretion, but still in the safe way to prevent abuse. But that's something that's still challenging in the context of Indonesia. So that's something that we learn, and the process is actually still going on. The implementing regulation is still in the process of finalization. Maybe in the next month, or yeah, in the next month or two, they will try to pass this implementing regulation. So I think that's from me. Thank you. So it's over to Mbak Santi.
Thank you, Tita. I will quickly explain this long-term postdoc project of mine because it's so in the long term it is comparative. It will compare Indonesia, Singapore, and the Netherlands, but I will explain the Indonesia part now. So like in other countries, Indonesia is facing rapidly aging population. Badan Pusat Statistik estimated 20% of the population are over 50 years old. This number is not as high as, for instance, the Netherlands or Japan, but Indonesia has its own unique challenges. An important challenge is that most people still relies on informal family-based system of care, but at the same time, people's lifestyles are changing to move from village-like living to more urban situation, which means smaller households and smaller houses. Anthropologists have warned at the same time that this also comes with a kind of indifferent mentality of younger people towards their elderly and elderly parents. Or they say it acuh, as we say in Indonesian. Asian Development Bank reported that around 10% of people over 60 years old in Indonesia are dependent on others for day-to-day living and care. Next. In 1998, a law on elderly welfare was enacted and its implementation was enacted in 2004. This is under the jurisdiction of Ministry of Social Affairs. However, the oversight or pengawasan was rather given to Bappenas by presidential regulation in 2021. This project looks into both state-organized and private or family-organized care and social security for elderly. It views law in proactive way, that it is also a determinant or a driver of change in society. Next. Data collection, it will involve a wide range of topics about sustaining lives of older are rarely used or referred to. And in the court database, there are a lot of information that can be derived from disputes over houses and inheritance, and these are also connected with care. Our data collection will involve questions such as how do older people live and receive care, who provides care for them, what they themselves consider to be good care, and whether or not the caretakers are also cared for. Does the state, through the BPJS program, support them when they stop working? Do they receive pension? How do they receive this pension? And so on. Next. So I want to quickly illustrate a project proposal that we are writing now, but with a disclaimer that it is not awarded yet, although it is, I believe, I'm not biased, a very important project. So the project will be an interdisciplinary research involving socio-legal scholars, myself, medical doctors from Faculty of Medicine at Universitas Mula Warman, anthropologists from UI, and environmental scientists from Erlangga. We will look into all aspects of lives of older members of indigenous Dayak communities in East Kalimantan. How do they deal with the changes with environment from rural to urban, with culture of community-based healthcare to formal state-based healthcare? And we will come up with a blueprint as a recommendation to make healthcare profession better and more sustainable. I hope we will get to do that. We will see whether the donors also agree with us about the importance of this project. So this is an overview of my project, and please do not hesitate to contact me if you have comments or have an opportunity for collaboration. Thank you. I give to Vera. Thank you. Santi.
Good afternoon. I will present our project, the Witness and Victims Protections in Indonesia's Criminal Justice Systems Perspective, Legal Reality, and Social Justice Initiative. The abbreviation is WVP and Legality. The Vollenhoven Institute, in collaborations with the Indonesian Witness and Victim Protection Agency, agreed to record the perspective of witnesses and victims within the Indonesian criminal justice system. This project is managed by Professor Adrian Bettner and coordinated by Vera Winis Tijawati Sumaru. Next slide. In implementing this project, VVI appointed 20 contributors who are Indonesian scholars, activists, journalists, and practitioners. The project descriptions record the perspective of witnesses and victims, and it also examined the efforts of governments of Indonesia to provide access to justice for witnesses and victims, highlighting the legal reality and barrier faced by witnesses, victims, and their family in seeking justice. The output of this project is a book chapter in the Indonesian language. The contributor discussed various legal aspects of victims and witness protections within the Indonesian legal system, paying particular attention to the experience of and viewpoints of victims and witness themselves. Next slide, please. Can you please go to yeah. Since 2006, Indonesia has established an agency with the role of protecting and guaranteeing the rights of crimes and witnesses. The efforts of the governments of Indonesia to provide a remedy and safeguard victims and witnesses through its agency have been ongoing. Then the question is, how does the criminal justice system in Indonesia protect the rights of and access to justice for witnesses and victims? As you see on the pictures, the fundamental questions arise through the experience of the senior Indonesian researchers, scholars, and activists when they were working closely with the victims and witnesses of many serious crimes, applying an interdisciplinary legal approach to better understand the experience, perspective, and expectations of witnesses and victims and their family in seeking justice. The research goals are analyzing the problem of access to justice for victims and witnesses and their families from a socio-legal perspective, suggesting solutions to improve access to justice. And next, please. VVI-LU clustered the research team into 5 clusters, which are sexual violence and human trafficking. Priscilla Yovia, Professor Sulistyo Irianto, and Sri Palupi will write this topic. The second cluster is human rights violation, Papang Hidayat, and Arif Arfiansa and Afrida Darmi, Herlambang P. Wiratraman, and Ita Nadia. Manunggal Kawardaya and Jane Rosalina are writing this topic. The third topic is corruptions and terrorism. The contributor are Vera Winis Tijawati Sumaru, Gilang Perdana, Erlangga Julio, Dominikus Savioko. They will propose a financial mechanisms to provide victims of corruption and money laundering with their rights to remedy, including the establishments of victim trust fund. Little bit promotions of my work. While Usman Hamid will explore his experience of advocating for terrorism victims. The fourth topic is environment and agrarian. The writer are Wiwi Awiati and Widodo Dwi Putro. The fifth topic is law enforcement institutions contributor. Ibu Laila Tistina is here. Aristo Pangaribuan and Yosef Stanley Adi Prasetyo. We estimate the writing will be finished at the end of this year and will be published online or ebook. I thank you for your attention. Any additional information you may need, and please do not hesitate to raise the questions during the Q&A.
Well, I'm quite sure that we presented so much that either you have no questions anymore, or you've so many questions that you can't ask them in the little time that is still available. So I suggest that we just end the session here. I'm very grateful for your attention. I hope that we gave a good overview of what we are doing here. I think it's a very good example of very close cooperation between Leiden and the Indonesian institutions. As you've seen, there have been a lot of results already, but there will be many, many more, and we would be grateful for your input to to promote our projects. And I hear that there's one question.
All right. Good afternoon, everyone. Let me introduce myself. My name is Ahmad Maulana Mabidin. I'm one of delegate from YIB, Yayasan Insan Cinta Bangsa, founded by ex-Vice President Yusuf Kala and the chairman of YIB, Professor Laude Kamaluddin. And honestly, I quite interest when one of speaker talk about adat deploy and indigenous community. I want to ask first why all of speaker didn't or nobody mention highlight or research about history Banten. There is Baduy, adat Baduy, community Baduy. I don't know exactly for some reason. I just want to ask all of you. So that's why I come to here. I want to learn. I want to know because I was born in Banten actually. Oh, okay.
Yeah.
I was born in Banten, particularly in Serang. So my question, first question, can I will focus on the indigenous legal reality and the Baduy community actually. So can the Baduy resist the modernization and uh, state intervention be understood as a form of critique against the failure of Indonesia legal system? And second question, how can socio-legal approach contribute to the developing more responsive legal policy indigenous community without undermining national legal? Just that's it. Thank you for the chance.
Yeah, thank you for your question. I'll start with the second question. Actually, a few years ago, Jantje Arizona, who works at UGM, defended his PhD thesis in which he looked at the use of the national legal system to protect indigenous rights. It's a very nuanced study which shows not only that a lot of rights seem to be recognized, but it also shows that the implementation of these rights is quite problematic, and that also applies to the Kasepuhan, for instance, which actually living close to the Baduy. And actually, that was one of the most successful cases where indeed some rights were recognized, and the Baduy also have had their rights recognized within the legal system. Which he mentioned in the book. So I can very much recommend you to read that book as about the possibility to sustain their livelihood and their traditional way of living in Indonesia. I don't think that the difficulties there have anything to do directly with the legal system, although the legal system plays a role in it, but that it's the modernization and also the rise of the monotheistic religions which are threatening the Baduy lifestyle. And actually on that topic too, PhD was defended a few years ago at Leiden University, which talked about the religionalization of Baduy, and I showed how many Baduy actually converted to Islam and how this has profound influence on their way of living. So I very much recommend you to read those two books. You can find them in the Leiden repository. They're freely accessible. So if you can't find them, please send me a message, and I'll send you the reference. Thank you. So then I guess we are at the end of the session. Thank you very much for your attention. Thanks very much to our Indonesian participants in Indonesia. Happy that you could be there, and I look forward to see the results of all these projects going on, and to our collaboration now and in the future. Bye.
Thank you very much.
I don't.